Hello, everyone. Good evening. Thank you so much for joining us for this next series in our financial empowerment and transition program. We have Gordon Holmes and Matt Gooden joining us tonight, and they are going to talk to you all a little bit about guardianship and a few different other account options, but guardianship seems to be the hot topic right now. So for those that are drawing near to that 17 and a half and like a day, I think number it is, this is going to be something that you definitely want to look into. They're going to discuss alternative options to guardianship as well. And if you all have any questions throughout this presentation, we ask that you please type them in the chat or in the Q&A, whichever is easier and more user-friendly for you. We will kind of take breaks as far as questions, so feel free to please ask those. There's no question that we don't want to answer. Yours may help someone else. So please don't be shy or ashamed. We love having participation. And before I turn this over, I will introduce myself. My name is behind me though. But my name is Sarah Beth, and I'm with the Council on Developmental Disabilities. We are a resource here in Louisville, and we serve individuals birth through lifespan with intellectual disabilities. We have everything from family outreach and supports to events that we host in the community with other partners and collaborators like these awesome guys. And we just try to help families navigate the road of what it looks like to have an individual with IDD. All of us at the council have at least one child, if not more, with an intellectual disability. So our passion fuels from our hearts, which is why we're here tonight. So I'm going to turn this over to Matt and Gordon. Again, if you have any questions, please feel free to put them in the chat in the Q&A, and we will get to them throughout the presentation. Thank you so much for being here.
Wonderful. Well, thank you so much, Sarah Beth, for the great introduction. And we've got a full program lined up this evening. We've got guardianship coming up first, and our special needs attorney, Matt Gooden, is going to address what's going on with guardianship, changes in recent years, alternatives, etc. So a robust discussion. And then after Matt finishes guardianship, then we'll transition over to me, and I will cover the ABLE account with changes that have occurred and pending changes coming and so forth. So plenty to talk about with that. And by the time we wrap up, it'll probably be 8 o'clock, and we'll talk about what's on tap for next week, a week from tonight, and go from there. So I'm going to do screen share, Matt, and bring up the, okay, let's see. Sarah Beth, can you help me out with screen sharing, please?
I am working on that right now. You should have already been able to do that.
Thank you so much. I appreciate it.
No problem. Okay, you should be good. Go ahead and try again.
Okay, here we go. Let's see. Oh, excellent. Perfect. Perfect. Okay. And okay, Matt, help us out here with guardianship and just prompt me and I'll advance.
Okay, I'll let you know when we need to switch slides. So welcome, guys. Thank you for joining us tonight. Like Gordon said, we're going to start with guardianship, and then we're going to transition about halfway through and talk about ABLE accounts, or also known as stable accounts in Kentucky. So Gordon, you can go ahead and advance a couple slides there.
Okay.
Already. So in speaking with families, there are a few common misconceptions about guardianship, and they primarily focus on what guardianship is, what it involves, and when it's appropriate, particularly when it's appropriate. So as we go through the slides tonight, we're going to touch on those misconceptions and provide some clarification so that you guys have accurate information and can make informed decisions about whether guardianship is appropriate for your loved one with special needs. So our agenda for tonight, we're going to start with what is guardianship. We're going to touch on some important terms that you'll come across if you do pursue guardianship. Some of the terms do cause some confusion. I'll give you an example of that as we go through. We're going to touch on some Kentucky specific laws related to guardianship because guardianship is very state specific. We're going to talk about the types of guardianship. Then we're going to talk about the process of guardianship, what that process looks like, including how a guardian is appointed, the liability of a guardian if they're not doing what they're supposed to do. And then we're going to talk about removal of a guardian and termination of guardianship proceedings if that ever becomes necessary. And then at the end, we're going to touch on alternatives to guardianship. And in many cases, in my opinion, the alternatives to guardianship is probably the most important discussion when we're talking about guardianship. And as we go through, I think you'll see why in many instances, one or more of the alternatives to guardianship would suffice and would be sufficient to provide support for someone that needs assistance with decision making. However, many families don't realize that or realize it too late. So we're definitely going to touch on those alternatives. Gordon, you can go ahead and advance to our next one. Okay, so what is guardianship? Guardianship is a serious legal proceeding in which the rights of an individual are taken away. So you lose the ability to do certain things or to make certain decisions. So this is why we want to carefully consider those alternatives that we'll talk about before we pursue guardianship because of the restrictive nature of the proceedings. Another reason for the cautious approach is because once guardianship has been established, it's very difficult to go back and, quote, undo the guardianship. To do that, the court would basically have to find that the individual is no longer disabled and therefore a guardian is no longer necessary. For our purposes, absent a significant improvement in physical or intellectual abilities of the individual with special needs, the guardianship can't be undone because we're not going to have that significant improvement. So that's why, again, cautious approach. Guardianship is illegal. We go back just one real quick, Gordon. Okay. Guardianship is a legal relationship between a capable adult, the guardian, and a ward. Ward is a dated term that's used in Kentucky to describe the person for whom guardianship is sought, the person with special needs. We won't use that term tonight. We're going to use the term protected person. Again, that's the person with special needs, the person for whom guardianship is sought. By legal relationship, we mean that you have to go through court in order to obtain guardianship. It's a court supervised relationship, and there are legal duties and responsibilities that come along with being a guardian. In most states, the law presumes that individuals 18 and over can make their own decisions and manage their own affairs. That's what's called the age of majority. This presumption presents us, the special needs community, with a problem because once our loved one with special needs reaches age 18, the law presumes that they can make decisions for themselves and they can manage their own affairs for themselves. And for most of us, we know that this isn't true and that our loved one with special needs may need some assistance, in some instances, a lot of assistance with making those decisions or doing certain things. So that's where guardianship and the alternatives to guardianship come into play to provide that assistance to the individual when it comes to those decision making. So with that in mind, that's why some families feel that it's necessary to apply for guardianship to protect their loved one with special needs. Gordon, we'll move on. All right, so some important terms to know about guardianship. The first is the protected person. That is the person for whom guardianship is sought. That's the person with special needs. Again, that term is called ward in Kentucky. So just keep that in mind. The petitioner, that's the person who files the forms to initiate the guardianship process. We'll talk about what those forms are in a few minutes. The respondent, this is the same person as the protected person. but this is the legal terminology used to refer to the protected person during the guardianship process. So on the guardianship forms that you'll have to complete to start the process, it will list petitioner and respondent. Respondent is the individual with special needs, the protected person, the ward, the person for whom guardianship is sought. Guardian / conservator. This is the person or persons, if there's multiple individuals, appointed by the court to handle the protected person's affairs. A small technical point here, the term guardian is sometimes used as an umbrella term. Technically speaking, the guardian is the person appointed to handle the protected person's day-to-day and medical decisions. The conservator is the person appointed to handle the protected person's financial affairs. So often the guardian and conservator will be the same person. If this is the case, you'll sometimes hear the term full guardian used. If a person has been appointed full guardian for someone, that means that they have been appointed as guardian and conservator. So they have control and decision-making authority over both the financial affairs of the individual and the day-to-day and medical decisions for the individual. But just know that there are two different terms used to describe two different roles. And the reason why I bring this up is because some of the forms that have to be filled out use these terms very literally, and sometimes it causes confusion. So as an example, I was assisting a family earlier in the year with guardianship. The mother was appointed full guardian, so guardian of the person and guardian of finances for her disabled son. Father was appointed standby, and we'll talk about what that means in a moment. One of the requirements for the conservator is to file an inventory of the respondent's assets 60 days after they're appointed. Basically, it provides the court with a list of the respondent's assets and financial resources so that the court knows what the conservator is managing for the individual. On that form, the document states, quote, "You are not required to file this inventory if you are the guardian for a disabled person." So the mother, after being told that this was a required form, called and was confused because she read that and thought, well, this says the guardian doesn't have to file that, but you're saying that I do. And this is where they're using the terms literally, because the guardian, yes, technically doesn't have to file it, but the conservator does. And if you're the same person, that means you do have to file it. So the requirement to file that form isn't being born out of the fact that you were appointed as the guardian. It was born out of the fact that you were appointed as the conservator. So that's just that's why I wanted to point that out, because it does cause some confusion. So the limited guardian is a more focused situation where the guardian has fewer duties and responsibilities in terms of decision making for the protected person. So their powers are much more limited. And again, this can be the same person, guardian or conservator. You could also have a limited conservator. So lastly, trustee, not necessarily a term that comes up for the guardianship proceedings, but it does come up when we talk about the alternatives to guardianship. So important term to know there. Trustee is the person who has the power of administration over trust property with the legal obligation to administer that trust property according to the trust document. We'll touch on that more in a few minutes. And Gordon, we'll move to the next slide. All right, so guardianship is very state specific, as I said, and it depends on state law and state regulations and state practice. So if you're seeking guardianship advice, you should seek guardianship advice from the state in which you're living, or presumably the state in which the respondent is living. Normally, it's the same state. So to that point, you should seek local legal counsel to get your state-specific information. An example of these state-specific rules in 2018, well, prior to 2018, Kentucky was the only state left to require a jury trial when making a disability determination in the guardianship proceedings. So in that instance, a jury would have to decide, is a person disabled and therefore do they need a guardian? Which made the guardianship process that much more difficult, especially for the protected person. In 2018, this requirement was waived. Now, a bench trial in which the judge makes the disability determination is permitted if all the parties agree, no objection is made, and all of the interdisciplinary team members, which we'll talk about in a few minutes, all agree that the respondent is disabled or partially disabled in the limited guardianship context. Gordon, we can move to the next slide. All right. So types of guardianship. At the outset, no matter what type of guardianship we're in, know that the guardianship can be temporary, so for a definitive period of time, or it can be permanent. In the full guardianship context, this is where, as we were just talking about, someone is appointed as guardian and conservator. So you have comprehensive decision-making authority over both the day-to-day and medical decisions of the individual, and also decision-making authority over their legal and financial affairs. So that's the full guardianship context. The limited guardianship context, again, decision-making authority and responsibility is only over selected items that the court finds that the individual needs assistance with. So as an example, if it was a case where the individual didn't need any assistance with day-to-day or medical decisions, but they did need assistance with their finances and managing those, it would be a situation where limited guardianship would be the option. A conservator would be appointed, but not necessarily a guardian of the person. So that's the limited guardianship context. A brief point about this, and a word of caution. Sometimes in speaking with families, they recognize the severity of the guardianship process, meaning the restrictions on the individual's rights, the fact that they lose those rights if guardianship is pursued. And they don't like that. None of us like that. However, they also recognize that their loved one with special needs assistance with decision making because they simply can't do it themselves. So they look at these options and they think, well, the limited guardianship context is perfect because it's kind of the best of both worlds, or so they seem. But a word of caution, in Kentucky, once guardianship, the process is started or initiated, the decision and the outcome in terms of limited versus full doesn't rest with what we as the mom and dad or petitioners want. The outcome rests with what the interdisciplinary team members determine is in the best interest of the protected person. So if they find that the person is wholly disabled and needs a full guardian, both for the person and their finances, that's the outcome that's going to result. So just know that if you go into the guardianship process wanting limited guardianship, that may not necessarily be the outcome because it doesn't rest with what you want. So just keep that in mind, a little word of caution. The last point here, just know that more than one individual can serve. So you can have a joint guardianship arrangement and a joint conservator. So you could have a co-guardianship where two people are serving. So just keep that in mind. Gordon, we can move to the next slide. Okay. So a little bit about the guardianship process generally. So the first is the cost. There is a filing fee to start the guardianship action in Kentucky. It's $100.50. A Kentucky specific rule, no personal checks are allowed. I don't know if that's the case in other states, but in Kentucky, no personal checks are allowed. There's also a processing fee if you're using debit or credit cards, so keep that in mind. Also, a point to recognize here, if two people are filing as co-guardians or someone is filing as guardian and someone is filing as a standby guardian, then there are two filing fees. So the cost is double. So keep that in mind. The forms for filing, these are the forms that initiate the guardianship process. So all of these have to be filed together. That's what starts the guardianship process. ALC 740 is sometimes referred to as the petition. Basically, it's saying to the court, I think this person is disabled, and here's why. ALC 745 is the application for appointment. It basically says, I want to be appointed as guardian, or I want to be appointed as conservator, etc. ALC 034, personal identifier data sheet. This provides the court with information on the respondent, just some general identifying information about them. The inquiry into qualifications, this is kind of a vetting process that the court uses. It'll have information about the individuals that are requesting to be appointed, a little bit about their background, especially if they're wanting to be the conservator, a little bit of background information about how they manage their own finances to make sure that they're a qualified candidate to manage someone else's finances. So a little vetting process. The transportation agreement simply is signed by the petitioner stating that they will ensure that the protected person is available for the interdisciplinary team evaluations and also for the guardianship hearing. And then the designation of process agent is only if the petitioner is a not non-resident of Kentucky. It doesn't come up very often. So all of those will be filed. Again, the filing fee, $100.50. If two people are filing, there are two filing fees. That second person will also have to fill out ALC 745. They will also have to fill out the inquiry into qualifications. So keep that in mind. Just some last miscellaneous points. All forms have to be typed or legibly handwritten in blue or black ink. Again, specific requirements. All forms have to be signed and notarized. I will say with COVID, some of the requirements have been temporarily waived. As an example, the notary requirement. Due to COVID, the courts, at least in Jefferson County, are allowing the forms to be submitted without the notarization. Basically, you were right on there, due to COVID, unable to notarize or something to that effect. How much longer they will allow that, we don't know, but that's the standard practice right now. Again, that might not necessarily be the case across the state. And for how much longer, we don't know. Best practice, if you can get the forms notarized, get them notarized. And that way you save a potential issue down the road. So last point, proof of respondent's social security number also has to be provided. It will be one of the items you will include with all of these forms when you're starting the guardianship process. Okay, so a little bit more about the process and what it looks like. So after all of those forms are filed, you submitted all of those, the county attorney's office will review everything that's submitted very briefly, just to make sure everything is included, all the information looks correct, nothing's blank, etc. And they'll determine whether or not the case should proceed. In our situations in the special needs context, this is very informal, done behind the scenes. You won't even hear anything about it. Provided it's approved, which it more than likely would be, the court will do a few things. First, they will appoint an attorney for the respondent, for the person with special needs, the protected person, as we're referring to them tonight, to represent them throughout the guardianship process and advocate for their best interest. This is the guardian ad litem, which is the term that's used. The court will also schedule a hearing date, which is typically 60 days in advance. During that 60-day window, the court will, or the interdisciplinary team members will meet with the respondent. Again, you have to make sure that they're available for those meetings. And that's the third thing that the court will do after the documents are submitted. They will appoint the interdisciplinary team members, which consists of a physician, psychologist, and social worker. Each member, again, will independently evaluate the individual with special needs. They will file a report with the court prior to that hearing, which is 60 days in advance. And basically, it will lay out their recommendations to the court on whether or not they think the individual is disabled, and if so, to what extent, and whether or not they need a guardian and in what context. They will also make recommendations in terms of whether or not the individual should retain the right to vote, whether or not they see the individual being able to drive either now or in the future. And they will also make a determination whether or not they think the individual should be present for the guardianship hearing. That's sometimes a concern for mom and dad about the guardian being present during the guardianship hearing. So that's one of the other things that will be addressed in that interdisciplinary report. A little administrative note here, the county attorney, I'm sorry, I'm going to mute that real quick. Please leave your name, number, and brief message, and we will return your call to the. All right, sorry about that. So the county attorney will, quote, prosecute the case. And what that means is, and this is an important point because it does create some confusion as well. The petitioner, again, files those initiating forms. After that time, they kind of take a step back in the action. The county attorney is charged with proving whether or not the individual is disabled and whether or not they need a guardian. The respondent, the guardian ad litem, is advocating for their best interest. So it's actually the county attorney and the respondent's attorney, the guardian ad litem, that are the parties to the action. The petitioner takes a step back. So just to understand how all of the parties are working and where they fit in with one another. However, I will say in my experience, most of the time, everyone is in agreement that the individual with special needs needs a guardian, that they are disabled, and therefore the adversarial nature isn't present in the guardianship hearing. So last point, at least one member of the interdisciplinary team will testify at the hearing. They'll lay out their findings. If they're all in agreement, all the interdisciplinary team members are in agreement, only one of them will testify. If there is disagreement, maybe all of them will have to testify. Again, usually they're all in agreement, at least in my experience. The petitioner may also need to testify, but that's less likely to happen. So a little bit about appointing the guardian, what that process looks like. So in order to appoint a guardian, again, this requires proof to the court that the protected person is not able to care for him or herself. They're not able to look after their own affairs, and it requires a physician's certification. And all of this will come through that interdisciplinary report submitted to the court. In some states, one or more state agencies may be involved. As an example, the interdisciplinary team will consist of a social worker. That could be an example where you have another state agency involved. All interested parties have to be notified. So you will notice on those forms that you have to fill out, there's a section for notice. This is what it's talking about. The key point to remember here for interested parties are close family members over the age of 18 for our purposes. So those are our interested parties that have to be notified of the action. The court appoints, again, someone to represent the individual during the court proceedings. That's our guardian ad litem. Their role is to advocate for the best interest of the protected person, but also to validate that the appointment is in the best interest of the individual. So that's their primary responsibility. they're basically the guardians, the last line of defense for the protected person in that instance. And the guardian's powers in dealing with the protected person's property and their affairs are going to be carefully restricted by law, court appointed, a legal relationship, it's court supervised, legal duties and responsibilities. So Gordon, we can move to the next slide. So because the guardianship is a legal relationship, as we said, and it has legal duties and responsibilities, if you're not doing what you're supposed to, you could be subject to legal liability. So the important points to remember here are that a guardian has to use reasonable care and caution when doing things for the protected person and making decisions on their behalf. So act reasonably, act responsibly. Unless a guardian acts negligently or unreasonably or irresponsibly, a guardian is generally not personally liable for any of their actions taken on behalf of the protected person. So absent one of those three items, generally not personally liable. So that's an important point. A guardian could, however, be liable for his or her actions where the protected person's property is damaged due to careless acts of the guardian, or if the guardian is personally at fault. So those careless acts arising out of negligence and the personally at fault resulting from intentional acts by the guardian. So there could be instances in which the guardian is personally responsible for their actions. Again, typically require negligence, guardian acting unreasonably or irresponsibly. So kind of building off that point, removal of the guardian. So a guardian can be removed by the court if they are not properly performing their duties. That makes sense. They can also be removed if the moved too many slides, excuse me. So they can also be removed if they ever become incapacitated, if they move out of state, if they die. These are more obvious examples of where the guardian would be removed. In those instances, a successor guardian obviously would need to be appointed. In those instances, this brings up our concept of standby guardian. So most of the time, if it's a parent, mom and dad, they want to file for guardianship of their child with special needs. One of them typically files as the primary guardian conservator. The other one typically files as the standby. Basically, that person is kind of in waiting. So if something ever happens to the guardian or they're ever unable to perform their duties, they are there and can step in to that person's shoes and serve immediately. So oftentimes this is more efficient to have this done at the same time. So you don't have to, if something ever did happen to the guardian, the court wouldn't have to go out and find someone and then appoint them. The standby guardian would already be vetted. They would already be approved by the court. They would be able to immediately step into the shoes and start serving in that role. So that's an important point there, the standby guardian. So termination of guardianship. So we've talked about what guardianship is, what the process looks like, talked about appointing and removing a guardian, but when does the guardianship as a whole ever terminate, if ever? So guardianship typically terminates when the protected person reaches age 18. This isn't necessarily related to the special needs aspect. This is focused on if the guardianship arose out of the fact that a child was under age 18. So if something happened to mom and dad and there was a minor child, there could be a guardianship that was established based off the fact that the child was under the age of 18, irregardless of whether or not they had special needs. So if that was the cause for the guardianship arising, then it would terminate once that child reached age of majority, age 18. It would also terminate when the protected person marries, if it's before age 18, or if they move out on their own, move out of the family house, and they're supporting themselves. That's another reason why the guardianship may terminate if the protected person is no longer incapacitated. So in our context, if the person with special needs was no longer disabled, again, unlikely in our context, but it does arise in some other contexts. So obviously, if the person is no longer incapacitated, no longer needs assistance with decision making, the guardianship would terminate. If the person dies, again, that's an obvious one there. In the case of a conservator, the conservatorship would end if the estate is exhausted, or if the estate of the protected person falls below the statutory minimum. And again, that's going to be state specific. So the protected person's residence, if changed to another state, could be another reason for terminating the guardianship. And a guardian has been appointed in the new state. Once that's happened, the guardian from the old state, that guardianship would terminate. So keep that in mind. Those are instances in which the guardianship could terminate. So now we're going to move to the alternatives to guardianship. And again, I think this is probably the most important conversation that we'll have on guardianship. And this is where a lot of the misconceptions come into play. Oftentimes you hear parents say that they've heard that once my child reaches age 18, I immediately have to go out and file for guardianship, which in some instances is true. It is the correct decision. However, there are many instances in which one or more of these alternatives could have been pursued and could have sufficed. So it's important to know these alternatives and to at least consider them prior to moving forward with the guardianship process. So we'll touch on representative payee, which most of you probably are already familiar with. We're going to talk about healthcare representative or healthcare surrogate in the medical power of attorney context. Different types of powers of attorney, durable power of attorney, specific powers of attorney. We're also going to talk about trusts as an alternative to guardianship. We'll touch on the trust aspect more next week when we talk about special needs trusts. Protected proceedings as an alternative to guardianship. Again, in limited situations, it could. And then also parental powers and how that can serve as an alternative to guardianship as well. So we'll start with representative payee. This is the person that is authorized by Social Security to receive and manage federal funds for a person who is unable to manage their own. So as an example, if your child with special needs receives SSI, this is an example where the representative payee may arise. So in that process, when you apply for those SSI benefits, at some point there will have to be a determination from Social Security's perspective as to whether or not the recipient can manage those benefits that they're going to pay to them. If they determine that they cannot, a representative payee has to be appointed. So this person doesn't have any legal authority to make personal decisions for the individual. They have no authority beyond managing those benefits from the federal agency. So limited applicability, but it's something that comes up very often. Many of you are probably familiar with this term. You may already be a representative payee for your son or daughter with special needs. An important point, separate records should be maintained, and the representative payee should not mix those benefits that the person is receiving with their own assets, no commingling. You need to keep separate records, keep everything separate. Periodic accountings may be required by Social Security. It's important to continually maintain detailed records of all activities. and to account for how the benefits are being used. It doesn't necessarily mean that you have to keep track penny for penny, but I would recommend creating an Excel spreadsheet where it has the total benefits coming in each month. There's some categories of expenditures, such as utilities, entertainment, things like that, total expenditures, and then the difference between what's brought in benefits and what's paid out in expenditures, and then you carry that forward to the next month. After a few months, you'll get used to the process. Again, not necessarily required. However, I do think it'll make your life easier if Social Security ever requests information about how benefits are being used, or does request those periodic accountings. You can easily submit that information to them. It'll make your life much easier rather than having to go back potentially a year to find out how the benefits were used. So keep that in mind. The healthcare representative, again, this is sometimes called the healthcare surrogate. This comes in play when we're talking about a medical power of attorney and also a living will. That's also where you'll see this term come up. So this person is appointed by an individual. So again, this is a case where the person with special needs would appoint someone if they feel that they lack or may eventually lack the ability to make decisions, but this is focused only on medical decisions. So your healthcare surrogate only has decision-making authority over the medical decisions, the healthcare decisions for the individual. An important point here to note, in the medical power of attorney context, and also in the durable power of attorney and the specific power of attorneys, which we'll talk about in just a second, our threshold that we have to meet at the outset is our capacity requirement, our legal capacity requirement. So the individual has to be competent. What we mean by that is that there has to be a basic level of understanding from the individual with special needs as on what they're doing, on what the document is that they're signing. So basically, if it's, in this case, a medical power of attorney, and son or daughter with special needs is appointing their parents as their co-healthcare surrogates to help them with medical decisions, the individual with special needs would have to have a basic understanding that they're signing the document, giving mom or dad the ability to assist them with medical decisions or to make those decisions for them. It doesn't necessarily mean that you have to have a full comprehensive understanding, but we do have to have a basic understanding. That can sometimes present an issue in the special needs context. So sometimes the powers of attorney aren't available to us. That could be a good indicator that guardianship is more appropriate, but you should at least touch on those to see if it's possible. Next is the durable power of attorney. Again, we have to meet that legal capacity requirement, so keep that in mind. This is a legal document that allows someone, sometimes referred to as the principal, to designate another person called the agent, so a principal-agent relationship, to make decisions and handle the financial affairs of the principal, of the person giving the power to someone else. So again, allow someone to appoint another individual to make decisions on their behalf, to speak on their behalf, to step into their shoes, etc. The person designated is called the attorney in fact, or your agent. There are several terms used. The appointment can be effective immediately, or it can become effective upon a future occurrence. Typically, that future occurrence is incapacity. So if the principal ever becomes incapacitated and can't make decisions for themselves, the power of attorney is effective. It's a springing power of attorney is the term that's used. It becomes effective, and then the agent can make those decisions for them because the principal at that point isn't able to do it for themselves. The general power of attorney can include many different things. Powers can include the power to receive federal checks. Again, that representative payee concept, handle bank accounts, handle transportation needs, buy and sell real estate, even make healthcare decisions if the medical power of attorney is combined into the durable power of attorney. So it can include a whole host of powers. It can be very broad, very general, and the power of attorney remains in effect during incompetency or disability. So if someone, that's the durable nature. So if someone executes a durable power of attorney and they later become disabled or incapacitated, it remains in effect. Their agent can continue to make decisions for themselves, which makes sense because most of the time that's where it's truly needed because the person can't do it for themselves. That power would end when the power is revoked or the individual with special needs dies. So this is an important point. If the child with special needs does meet the legal capacity requirement and therefore can execute a power of attorney, it's important to remember that they still retain the ability to make decisions for themselves. They can revoke that power of attorney if they wish. They can amend the power of attorney if they wish. It's just giving someone else the ability to assist them with decision making if they need it or if they want it. So just keep that in mind. Individual still retains decision making authority. All right, we'll move to the specific powers of attorney. A little bit more limited in applicability. Here, again, it's a legal document, so we have to meet legal capacity. Legal document that allows the principal to designate an agent to make specific decisions or manage a specific asset. So typically this arises when we're talking about a specific bank account and managing that for an individual. If that's the case, the bank may provide a form to effectuate this, or the person could have an attorney draft the specific power of attorney. But sometimes the banks do have, if it's related to the specific bank account, they will have a form potentially that you can fill out. Now, the specific power of attorney is preferable to a joint bank account arrangement or a broadly joint account arrangement, because a joint account arrangement where you just add someone to your account. So if it's someone with special needs and we just add someone else to the account owner, it creates that ownership interest for that other individual that's added, that's being asked to manage the account. The issue with that is that the ownership interest opens that account or that asset up to the other individual's creditors if they have any. If they ever file for bankruptcy, it could be subject to that. If they ever get a divorce, it could be subject to that. So the joint account is not the most ideal situation because of those risks. So the more efficient, the better option to provide assistance to the individual without adding those risks is the specific power of attorney, giving someone the authority to manage a specific asset for their benefit. So the trust as a alternative to guardianship, again, a little bit more limited applicability. A trust, generally speaking, is a relationship where property is held by someone called the trustee for the benefit of the trust beneficiary. We're going to, again, touch on this more next week when we talk about special needs trusts. It's created by the owner, sometimes referred to as the settlor, the trustor, or the grantor. In my practice, grantor is typically the most common term, but the grantor, or the person creating the trust, transfers property to the trustee. And again, in the special needs trust context, that may be the same person. The grantor and the initial trustee may be the same person. And then the trustee holds that property for the trust beneficiary's benefit, so the person with special needs. So how is this an alternative to guardianship? Well, it does offer that assistance with managing certain assets for the benefit of the person with special needs. and that decision-making rests with the trustee. Example, special needs trust, again, created to benefit a person with special needs. We're going to talk about this more next week. A special needs trust can do a variety of things. It can receive assets, a variety of assets, including inheritance, court settlements, insurance claims, gifts, life insurance proceeds, a whole host of things can go into a special needs trust. The main benefit for our purposes is that it protects current or future government benefits eligibility. That's our real focus when we're talking about protecting an individual's special needs. And it can pay for a variety of things. It can pay for medical care, special equipment, education, entertainment, transportation, schooling, you name it. It can cover a lot of different things. So there are different types of special needs trust, which we'll go into more next week, but a trust could be a quasi alternative to guardianship in some context. All right, protective proceedings. So this arises in where someone has filed a claim with Adult Protective Services or Child Protective Services, and the court, again, can appoint someone or may issue a protective order for a minor or an incapacitated person, someone with special needs, to protect that person and their property and their affairs if they deem after an investigation is done that that's necessary. So it's just arriving at the protection in a different way. It's arising out of someone having a concern, filing that claim. Again, Adult Protective Services, Child Protective Services are examples where this may arise. And it could potentially result in a trust being established for the protected person's benefit as well. So just know that a trust could potentially arise out of this as well. And then lastly, we will touch on parental powers and talk about how that can serve as an alternative to guardianship. So the parents of a minor, again, someone under the age of 18, can execute certain things as mom and dad on behalf of their minor child, such as consents, waivers, even powers of attorney. We do this all the time with waivers to participate in sports activities or to go on a field trip, etc. But again, once the individual turns 18, they are presumed to be able to make decisions for themselves. That parental authority to make those decisions for the child end. For our purposes in the special needs context, a parent can file for guardianship anytime between age 17 and 18. So once you reach that age 17, you can begin the process. One of the reasons why we have the restriction that you can't file before age 17 is because of this reason. The parents are already the de facto decision makers. You already have that authority. Therefore, you don't need to apply. You don't need to petition the court for that because you already have it. So that is our discussion on guardianship and the alternatives to guardianship. Do we have, Sarah Beth, any questions on guardianship or the alternatives?
We do not have any questions.
Okay.
But anyone that is watching, do you have a question now? We would love to hear from you.
And if you don't have a question now, but if you think of a question as we're going through, feel free to put it in the chat box, or Gordon and I's contact information will be at the end. Feel free to email us or reach out. We'll be happy to answer those questions. So if we don't have any questions, we will switch over and I will turn it over to Gordon. He will talk about ABLE accounts as they're nationally known, or in Kentucky, they're called stable accounts. And a brief note, if you do have questions or want more information on stable accounts, I do have a handout that I can email to you at the end, or just send me an email following the presentation or tomorrow if you want that information. So Gordon, I will turn it over to you.
All right. Thank you, Matt, for the great review of guardianship. Now we have able accounts to finish out the remainder of our time this evening. The ABLE Act came into being, it took about 7 years to get through Congress. It was renamed the Stephen Beck Jr. Act, who is the individual that championed the cause for those many years to get it to Congress. It passed at the end of 2014, and then it was further improved upon as a part of the Tax Increase Prevention Act. We will look at that and also the Tax Cut and Job Acts of 2017 and how ABLE has changed. So to be eligible for an ABLE currently, the disability needs to have occurred prior to the age of 26. For most individuals with intellectual or developmental disabilities, the onset is prior to 26. However, there is currently a move afoot to raise the age, and so we're hopeful within the next year or so that the age 26 may actually be raised to as much as 46, so that the age required that your disability has to predate may go up. But for now, the disability needs to have been identified or documented prior to the age of 26. In some cases, if the diagnosis started before 26, eventually may result in death, such as spina bifida, hemophilia, or muscular dystrophy, then that will suffice. Can be, again, greater than 26 when opening the account, just looking for the origin of the disability to be prior to the age of 26. If age criteria is met and the individual is currently receiving SSI and or SSDI, Social Security Disability benefits, then one's automatically eligible. If they're not receiving SSI, therefore they've not had to meet the standard of disability for Social Security, then we look for a letter of certification from a physician, typically as a part of the application process. As far as limits are concerned, generally speaking, the maximum annual contribution is $15,000. We'll talk about an exception to that in a moment. It's tied into the annual gifting limit, and there is proposed legislation currently for tax changes that may affect the gifting limit. So we will have to see what impact that has upon ABLE accounts. But again, at this time, $15,000 is the annual limit, and the maximum for an ABLE account is $100,000 if one is on SSI. So if technically $15,000 were contributed over a period of 7 years and the balance went above $100,000, then that would create a temporary suspension, not a termination, but a temporary suspension of SSI, until which time the ABLE account came back down under 100,000, presumably by spending some of the money. For those of you in Indiana, the maximum ABLE for Medicaid eligibility is $450, in Kentucky $350. So again, the limit is quite high. We've not seen any limits that high yet, but maybe in time. Okay, so one ABLE account per person. So if an individual has an ABLE account, a second ABLE account cannot be established. So if you've got 2 or 3 grandparents and they all want to set up an ABLE, you're limited to one ABLE account. They can all contribute, but again, a single account limit per individual with special needs. And then the 15,000 is the aggregate limit from all people contributing. So it was set up that way so that there would be an easy system to monitor just what was going in or coming out of an ABLE account. That is a difference, of course, with 529 accounts, after which this legislation was patterned. With a 529 college account, there can be multiple accounts, unlike ABLE. Contributions can be made by most anyone, can be made by the beneficiary themselves. So that's correct. The disabled person's own money is welcome in an ABLE account. In fact, ABLE accounts have been used a number of times where one might be targeted for the home and community-based waiver services, or potentially after waiting a number of years, the Michelle P. waiver. But while they've been waiting for the waiver, money has accumulated in a checking account or a savings account, this type of thing. Not a problem because they hadn't been targeted yet. But once you're targeted, Medicaid's going to be very interested in knowing that the resource limit of $2,000 is being observed. So if one has 5,000 in savings, oftentimes dealing with that issue can be as easy as opening up an ABLE account, maybe tossing $3,000 or $4,000 in there, bringing them down under the $2,000 limit in order to be eligible and receive waiver services. So ABLE accounts can really be helpful in a pinch, and we'll look at some other situations where it could be helpful in a moment. But again, it's primarily a vehicle to deal with resource issues. That is, if I'm limited to $2,000, how am I ever going to save or accumulate? And for the consumer, oftentimes ABLE is the answer. There were enhancements made in 2017, and this is where we'll get into how the limit for contributing can be actually more than $15,000. So the tax and penalty-free rollover of up to $15,000 from a 529 account was a part of the enhancement that occurred with the 2017 legislation. So it is possible if the 529 account has a family member as a beneficiary, the same owner, this type of thing kind of matches up, that funds from a 529 account that may not be needed for college or technical school or that type of thing could be transferred into an ABLE account. If a 529 account is transferred over to an ABLE, it does count toward the $15,000 annual limit. So if one had $15,000 in an ABLE account and it was transferred to in a 529 account, it was transferred to an ABLE account, then that would use up the $15,000 allowed for that year. Also, in some situations, retirement funds can be transferred over to an ABLE account. So if an individual took a part-time job and there was an associated 401k with that position, and that does happen in part-time employment frequently. In fact, I think Walmart makes available to part-time associates participation in their 401k. While you're an active employee, 401ks are typically not a problem because you're active. You can't raid the account. But if one did change jobs or moved on and suddenly the 401k was not with an active employment situation, it can become a resource issue. It would be possible, at least in some cases, to transfer funds from the 401k with the ex-employer to an ABLE account. So a question has come up. We'll try to deal with them as I see them. Can Social Security decide that an SSI recipient is not eligible for an ABLE account because of being determined disabled by Social Security at age 36? I'm asking for my son, who is on the autism spectrum. And the answer is when to what age can we trace back the disability? So as an example, if one was not on SSI until they were 30, meaning there's no Social Security involvement, there's no Social Security standard that has been met to prove the disability prior to age 30. However, there is evidence from a medical standpoint, diagnosis standpoint, that is that the disability documented at age 30 in the form of SSI beginning actually originated prior to age 26. I certainly think a compelling case could be made for being eligible for an ABLE account. Where ABLE, at least at this point, is a struggle is when a person's diagnosis occurred as a result of an event that clearly occurred after age 26. So this would be, as an example, someone at age 30, working full-time, has a family, children, living life to the fullest, were to fall down a flight of stairs at work and sustain a traumatic brain injury that causes them to be disabled going forward. Clearly, the disability resulted from that accident, which occurred, as an example, at age 30. That would be after age 26. So until which time we're successful in getting the age limit raised for ABLE, those events, another example would be if someone at the age of 45 had a stroke and prior to that, no disability and evidence, another example. And there are some situations where perhaps someone is diagnosed with Parkinson's when they're 55, this type of thing. Unless there is some way to tie, at least for the moment, the disability back prior to the age of 26, it's going to be difficult. But in the case that was outlined in the question presented, I think a good case could be made. It would be rare that someone would be age 36 on the autism spectrum and there'd be no evidence of that disability dating back at least 4 years. Hopefully that is helpful. I welcome other questions as we move through the material. It kind of keeps it interesting as well as relevant. So add questions to the chat if you could, and we'll be happy to answer them. Okay, all right. Let's see here. Credit or qualified retirement savings contribution may be eligible if filing taxes due to earned income. So if you're doing submitting taxes because of earned income due to a job, one may be eligible for the qualified retirement savings contribution. Account holders with earned income, speaking of having employment, based on the 2017 enhancements from the Tax Cut and Jobs Act, actually have the ability to contribute more than $15,000. So the limit is set on an annual basis and makes adjustments based on the national poverty rate. But bottom line is if one has employment, therefore earned income, not received as gifts or Social Security income, but earned income, then that earned income subject to an annual limit can be added to the $15,000 to determine the total amount that can be contributed. So for 2021, it's $17,760. So believe it or not, for someone that, let's say, earned $10,000, the limit's $25,000 for that year. It's added to the $15,000 to determine the overarching limit. Again, I welcome questions. Feel free to.
We do have one question, Gordon.
Okay.
Can you put a savings bond in a stable account?
Okay, great question. At this juncture, the structure of ABLE accounts are such that they will receive cash. So whatever it is that you have would be converted to cash, and most often it is an electronic transfer of the cash from a checking or savings account. So when an ABLE account is set up, basically the name of the institution, the routing number, and the account number is entered, and an electronic transfer of funds is arranged from the financial institution to the ABLE account. So ABLE accounts do not hold property. They would not hold an IRA. They would not hold, your Apple stock, this type of thing. When the monies go into an ABLE account, you do get to select from an investment, a range of investments, this type of thing. And so it can be higher risk, lower risk, moderate risk. So you do have a variety of options. So I do not want you to think that funds sit in an ABLE account not earning either interest or receiving investment returns. Of course, with investments, there are risks as well. And some people are risk adverse and may want to invest more conservatively. But similar to a 401k at work, funds go in by payroll deduction, this type of thing, and then funds are invested based on the list of different investment divisions made available as a part of the 401k plan. ABLE is similar. You would select from the list based on the 401k plan that you select. And we will get to in a moment, because there are actually more than one ABLE account, stable for Kentucky, but there are other options. We'll touch on that in a moment. On the way there, I'm frequently asked, well, once the money goes in, will I ever see it again? Is it like goodbye to my money and there it went into the ABLE account? Well, the news is good because the range of expenses or items that one can make a withdrawal from an ABLE account to pay for is significant. So this is just a sampling of examples of where funds could be withdrawn from an ABLE account: education, housing, and you can read on through the list, even funeral, burial, all kinds of things. So lots of reasons that funds can be withdrawn from an ABLE account. You even see financial management and administrative services. So if someone is disabled, but perhaps they're able to work, but they just need someone to help pay their bills and file their taxes and these types of services, then one could make a withdrawal from a funded ABLE account to pay for that extra type of help. speaking of being on the spectrum, I can't tell you how often parents will come in and there's some expectation of employment, but money management is just not there. And it's a great concern for the parents because, you know, if they're making money, what's going to happen to the money? Can they be taken advantage of? Will they not pay their bills? Will they lose, lose out on things or go into foreclosure or who knows what because they're not good with money management. So if monies are in an ENABLE account, it can help provide those services along with a lot of other things. Also, travel. I know my wife and I are looking at traveling for the first time and seemingly forever. And so as we all start traveling again, ABLE accounts can fund vacations, opportunities to travel for enrichment, et cetera. So that's another example where ABLE can be helpful. Okay, great question. Thank you.
We do have one more. It says, my daughter has some bonds in her name and will be turning 18 soon. The bonds haven't fully matured. Current value is $1,926. Would it be best to cash out now before she turns 18 and we apply for her SSI?
Okay. Well, if the bonds are not going to mature by age 18, then I see no reason to put it off. Usually the less activity that occurs within close proximity to the application for SSI, the better. At the same time, as to what happens with the money, the individual is a minor. And so cashing out of the bond, it isn't going to accomplish much to simply liquidate the bond and then put it in a savings account in their name because it's still associated with them and their social security number. So the options available in a situation like that would be to liquidate the bond, which can typically be done at any commercial bank, and then take the funds and decide things perhaps that the individual with special needs needs. This could include placing the funds in an ABLE account for future use if there is nothing immediate. It could also include the purchase of clothing, electronic devices, a cell phone, basically most anything that is for their benefit. And that they are a minor, it would not be wise for the parents to use the funds toward food and shelter expenses, and that any parent is expected to provide that for a minor child. So we're looking at either stashing it in an ABLE account to figure out later what you want to use the funds for, or spending it on something for the benefit of the individual other than the basic essentials of living. Now, if it does go into an ABLE account and we're working together to help plan for that child's future, there's certainly no reason why, since legal expenses can be covered by an ABLE account, that a withdrawal could not be made from the ABLE account to pay for the special needs trust, since that's clearly for the benefit of the individual with a disability. And this is coming up more frequently with what can we do with the money, and if it's a similar time frame to doing some special needs planning, then those funds can assist with planning as it relates directly to the benefit of the individual or consumer with special needs. So in some cases, maybe those funds can cover the special needs trust, and that could be as much as half of the cost of estate planning for the parents. So there are creative ways to use funds to truly benefit your loved one with special needs. Let's see. Okay, if there are any additional questions, or it looks like we're current. Okay, wonderful. Great. Was there something else? No? Okay. All right. ABLE payback. So states do have the ability upon the death of the account holder, meaning the consumer with special needs, to seek to reimburse themselves for Medicaid benefits provided the individual from the time the ABLE account was set up going forward. And so one would want to keep in mind, certainly before they build, that 100,000 that we talked about was possible without losing SSI in an ABLE account, especially if the nature of the special needs may make the individual medically fragile, where there is a chance that something may happen to them. And it would be most unfortunate if the balance of the ABLE account simply went to enrich the state. So do keep in mind that ABLE accounts do have a Medicaid payback clause. Not all states are imposing this, but what comes can go, and the states may change their mind. I would envision Kentucky perhaps would be a little more aggressive than some states because of the lengthy wait for some of the Medicaid waivers. The state of Kentucky is in the hunt for funds to help fund these Michelle P. waivers, the supported community living waivers, and so forth. And so I wouldn't put it past the state to seek reimbursement from ABLE accounts from individuals at the time of their passing. We will draw a distinction in our meeting next week between special needs trust and ABLE accounts and this type of thing. So it'll help complete the picture. So please do stay tuned and make sure to join us next week when we talk about ABLE accounts. Okay, most states have implemented ABLE accounts, but not all. And states can opt to use someone else's account. So Tennessee has an account, but if it didn't, it can say, yeah, we'll use the stable account from Kentucky and develop an agreement or arrangement with the state of Kentucky. Again, most states have them, have their own. I think over 40 states have implemented these, but bottom line is most everyone in the country that's eligible for ABLE has access to an ABLE account. Then if you'll notice at the bottom, we do talk about some options. So you've got Kentucky Stable, there's Invest ABLE Indiana. Neither Kentucky nor Indiana at this time offers a specific tax incentive to using your home plan. So what that means is that without a specific tax incentive, such as a state income tax deduction or a state income tax credit for using specifically your home state plan, such as Kentucky Stable. As a result of that, you're free to use whoever state plan you want to, assuming that that respective state allows for out-of-state individuals to establish plans. There were limitations early on. Some of those have been lifted, but suffice to say you can't pick from 40 different plans necessarily, not that anyone would want to take that on, but you do have options outside of Indiana, or excuse me, Kentucky or Indiana. One of those is the Virginia plan. And as you know, or may know, the ABLE accounts were patterned after the 529 college accounts. And the Virginia ABLE, or excuse me, Virginia 529 is one of the largest and most successful 529 college accounts. It's called College America. So it makes sense that the Virginia plan for ABLE accounts are ABLE America. And what is a distinction with the ABLE accounts or the ABLE account of Virginia is that it is actually set up for you by an advisor, someone such as myself. It also can be helpful if you have an existing relationship with American Funds because it kind of keeps things together for you. But nevertheless, it is the one plan in the United States where an advisor can actually set it up for you. Otherwise, the Kentucky plan, the Indiana plans are largely self-help, meaning you go online and set it up. It's not extremely difficult, but not everyone is tech savvy or comfortable going online and entering the information, including your bank account information, et cetera. So if for any reason being online is not your thing, or you do need, you want someone to assist you in setting up the account, then the Virginia plan, which you do have access to nationwide, is a plan that can be set up with the assistance of an advisor. Okay, opening an ABLE account. Again, the state determines the enrollment process, whether you're on your own or with the assistance of an advisor. States have minimum contribution levels, different fee levels, this type of thing. So again, these things vary state by state. Some have a debit card, such as Indiana, where you can spend money from the ABLE account by using the debit card. So again, nuances and differences between the plans. This slide is designed to provide you with a website where a good deal of information about various state plans is available. And so if you want to, and I was just on the website earlier today, but if you want to do some studying about ABLE, then the ABLE NRC for National Resource Center.org is a good resource to go to, kind of a clearinghouse for information on ABLE accounts. We're going to get to some examples here momentarily. Looks like we're okay on chat and questions. So an ABLE account may not be the best vehicle, in all situations. So if you're sitting there thinking, wow, this ABLE sounds pretty good, but these are situations where you may want to think twice. An example would be an inheritance, settlement, judgment, or contribution from a family member for a beneficiary that exceeds the maximum annual contribution limit. So if your child with special needs were to inherit, $50,000 from some great aunt or uncle unexpectedly, $50,000 is not going to fit into an ABLE account. Or if they were to receive a settlement or a judgment, an example is I have a roughly 30-year-old that had a traumatic brain injury at roughly age 12 when he was the victim of an auto accident, a pedestrian struck by a vehicle. So he received a settlement, a substantial settlement as a result of his traumatic brain injury, and it exceeds the limit available with ABLE. So that's just one example. Another would be where contributions are not coming from an individual with a disability, meaning it's not from the consumer, maybe it's a parent or a grandparent. And perhaps since it's their money and they can do what they want with their money, they may want to consider making those contributions to a third party special needs trust that we will talk about next week that would not have the Medicaid payback associated with an ABLE account. What does that mean? It means upon the death of the consumer or family member with special needs, the money stays with the family instead of going to reimburse the state. Another example, again, with the diagnosis occurring after 26, meaning there's no way to provide documentation or proof the disability occurred prior to 26. It's not a good fit for ABLE. Another example would be where there's no guardianship, but the person just cannot manage money. So putting money in an ABLE account is going to put them in charge of this account, and they may just not be up to do that. Or an ABLE account can be used in combination with other savings vehicles, including a special needs trust. So in some cases, what we're seeing is ABLE accounts are holding small amounts of money for small expenses, but the majority of the funds are being held by a special needs trust where the trustee, as Matt was talking about earlier, is able to oversee the substantial funds, almost like an allowance of sorts. So we're seeing more and more creative ways to use ABLE. So I promised examples, and here they come. And we're right on time to finish by 8 o'clock, so please don't get concerned. So it's better suited. ABLE accounts are better suited for small settlements, unexpected inheritance, or savings of the consumer. Thinking of it as a put and take or a save and spend type of account, here are some examples. Example 1, a grandparent dies and leaves $10,000 directly to each and every living grandchild. For the grandchild with special needs, it must be spent, used to prepay final expenses, or deposited into an ABLE account. So you're kind of limited on options. If $10,000 is coming as an inheritance for the child with special needs, but because with an ABLE, their own funds are welcome, that $10,000 could be spun off to an ABLE account for future use, and they are kept under the $2,000 resource limit. Another example, which is actually a real life, both example 1 was real life. Grandparents living in Cincinnati actually passed away and left $10,000 to a grandchild in Kentucky with special needs. So that's real life. Example 2 is real life. The school bus incident where a child non-ambulatory in a wheelchair, and the wheelchair was not anchored, and it literally rolled out the back of the bus, and the goodness, God love the child, they face planted on the asphalt and required surgery and a variety of things. And needless to say, there was litigation. All ended okay, but for all of the angst and medical treatment, et cetera, the school did agree to pay $15,000 reimbursing for all expenses and trouble, et cetera. Well, $15,000 for this young person in school might seem like a godsend, but they can't have $15,000 if they're on the Michelle P. waiver. So we had to do something with the $15,000. It happened to, of course, be the limit for an ABLE account. So we were able to sweep the 15,000 into an ABLE account. The child retained their eligibility for the Michelle P. waiver, and that 15,000 is now investing and growing for their future use. And another example, number 3, an individual with special needs gets a job resulting in earned income. So I know that Matt was talking about transition earlier and so forth. But this kid comes out of high school and maybe a certificate of completion or something. But nevertheless, they got a job. They got a part-time job. Maybe it's at Goodwill. Maybe it's at Lowe's. This type of thing. A lot of people hiring these days. It says they want to save some of it, meaning they need some of it for expenses, but they want to set a little aside, save up for something, maybe a vacation, furniture, additional schooling, maybe a used vehicle. But nevertheless, they still have SSI, which they can maintain even while they're working part-time. As we discussed last week on government benefits, they have Medicaid, they have Medicaid waiver services, whether it's the home and community-based waiver or the Michelle P. waiver, so gosh, how can I save some of my earnings and yet keep all of my benefits? An ABLE account would allow for funds to accumulate for future use without being subject to the $2,000 resource limit. So it's an opportunity for them to be rewarded for working and for saving. Let's look at a couple of other examples, because ABLE accounts so far, we've talked about handling resource issues. That's what really ABLE accounts do best. By sweeping the inheritance, legal settlement, paycheck, 529 savings or investment account into an ABLE account, the consumer is back under $2,000 and their benefits are saved. But let's look at a couple of examples here where ABLE may or may not be able to fix all the issues. So example 1, a consumer age 22 is receiving SSI and has a part-time job, earning $500 a month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI as a result of the income. So as we discussed last week, the first 85 is forgiven. The other 415 would be subject to a 50% reduction for 207.50. So putting that $500 paycheck in an ABLE account would enable this consumer to save and accumulate funds for future use, staying under the $2,000, but it would not enable them to avoid the reduction on their SSI benefit for having earned income. Of course, this assumes they're not a student, where they might be subject to the student earned income exemption that we talked about last week. Example 2, a consumer at 35 is receiving $500 a month from SSDI. They also receive a benefit off of a parent of $1,000. That puts them at $1,500, and they're earning $900 a month from their employment or their job. They can save up to $25,800 a year because of the earned income on top of the $15,000 to the ABLE. So no problem in keeping themselves under $2,000 in resources. However, there is a monthly income maximum for maintaining Medicaid eligibility of $2,382. Again, the monthly max at $2,400, $1,500 plus $900. They're exceeding that. An ABLE account will not allow them to maintain their Medicaid. So in that case, one of the trusts that we will talk about next week, a Miller Trust, may be indicated. So it's like having, your tool belt and using these different tools to solve different problems from a benefit standpoint. So this talks about a special needs trust. I think we can defer to next week on that in an effort to finish on time, because we are going to do a deep dive into special needs trust next week. And if you think you know special needs trust, please tune in, because you may be surprised to learn that there are about 5 different types of special needs trusts. And a lot of people are not sure which type of trust they have, or if they have the appropriate type of trust, or if it can be funded while parents are living or has to wait until they die. I mean, there's a lot more to special needs trust than most people realize. So I know that Matt and I are really excited about the workshop that we have for you next week, where, again, we're going to do a deep dive into all these different types of special needs trusts. I often say special needs trusts are one of the greatest gifts we as a special needs community have been given. And we owe it to ourselves to take advantage of this. So let's see here, boom. as promised by Matt, as we hit 8 o'clock, contact information is shown. I do want to remind you, as a result of participating in the series, we're providing a free follow-up consultation. And if you will email either of us, frequently the consultation starts with me and we'll make the referral over to Matt. Jamie Sturchy, our parent advocate, asked me to mention to you that we do have appointments available on Thursday, the 27th of May, which is the Thursday after the 4th workshop in the series. And we do have, I think, 2 or 3 openings still available on Thursday, the 27th. And we do want to help as many families as we can. The follow-up consultation is free, as in it costs you nothing. And so it's as easy as just sending us an email to indicate your desire in taking advantage of that. What's powerful about the individual consultation is we're able to kind of separate the wheat from the chaff and figure out of all we cover, what applies to your situation. An example is, as I was on the phone not more than a couple of hours ago with an 84-year-old that has a 58-year-old with special needs. Well, needless to say, not everything we cover is going to apply to a situation like that. And that's where we figure out what does apply, how can we help? And she was, referred because someone else that was on a workshop like this knew about their situation. And nothing has been done to plan for the 58-year-old thus far. And she's most anxious at 84 to get something going for her son. So at any rate, I want to once again take advantage of the opportunity to thank the council, the Louisville Council on Developmental Disabilities, for making this whole series possible, for Mary Beth joining us this evening and helping field questions in the chat and so forth. And of course, Matt, my partner in this effort to bring this important information to you. Let us know about taking advantage of the free follow-up consultation, and then also look for your post workshop email that'll be going out, and make sure to tune in next week. I'm going to stop sharing and yield back. Sarah Beth, anything you want to add as we wrap up this evening?
Sure, absolutely. I will put on our Facebook page Gordon and Matt's information, just to give you all an extra reminder of how to get in touch with them if you are interested in scheduling that free consultation on the 27th. So that way you can contact Jamie at their office directly. Again, if you all have any additional questions, or you kind of go back and ponder all this information, we know it's kind of a lot, feel free to message us on social media as well at the council, or give us a call. We're in constant communication with Matt and Gordon, so we can translate, anything over to them as well. I just had a person ask something from last week and followed up with Jamie in an email about it. So we welcome questions. We would love to help you all in any way that we can. We know this is a lot of material, but it's very useful. So feel free to reach out if you need anything. And it looks like we actually did just get one more question, guys. Speaking of that, it says, we live in Indiana. Is each county different as far as guardianship? Is it best to have an attorney assist with obtaining guardianship? Do you need to wait until the child is 18 for a court date? All good questions.
Well, that kind of has both of us. But I would say take advantage of the consultation, because the guardianship process is based on state law as opposed to county. However, you're going to go before a judge in your respective county, and judges can run their show just a little different in every county. Also, the scheduling can be different. Some of the processes a little different, and handling the virtual part of it, and and so forth. So let us get together. And we'll need an attorney licensed in the state of Indiana to assist with that. And the cost for guardianship is all over the board. So let me assist so that we get you an attorney that will do a very competent job, like Matt would here in Kentucky, but yet isn't going to take you to the woodshed. So at any rate, please request the follow-up consultation. not only because of the guardianship with turning age 18, that means you're going to be starting your, likely starting your SSI journey. And please let me coach you and prepare you for SSI, working through the worksheet for establishing the monthly contribution to food and shelter expenses and so forth. There is just so much in turning age 18. So perfect timing to, again, take advantage of the free consultation. We could do it virtually, or if you want to hop the river and come meet with me in the Louisville office, then that's fine as well. Either way, we'll get it handled for you. Anything to add, Matt?
Yeah, just to kind of echo that point, very state specific, but counties, they each do their own thing a little bit different. So you want to be sure to tune into that. But again, thank you guys for being with us. Please join us next week when we talk about special needs trust, and then 2 weeks from now when we talk about life care planning. Kind of pull all the topics together. Hopefully you'll start to connect the dots. So again, thank you. If you're interested in the handout on stable accounts, again, that's Kentucky specific, the stable program here in Kentucky, send me an email. I'll be happy to share that information. So.
All right. Thank you all so much for tonight. Very helpful information.
Good night.
Thank you. Have a great night.
Thank you.